On a day that will be remembered as a seismic shift in American legal history, the United States Supreme Court handed down a decision that has sent shockwaves through every corner of this nation. 8 justices united in a ruling that could redefine the Second Amendment for generations to come, while one lone dissenter stood against the tide. This isn't just another court case buried in legal jargon. This is the moment that changes everything. Gun owners across America are asking themselves right now, is this the victory we've been waiting decades for, or does it open a door we never saw coming? Anti-gun politicians are scrambling, state legislatures are in chaos, and the constitutional battle over your right to bear arms has just entered an entirely new arena. If you care about your rights, if you care about the future of the Second Amendment, you need to hear every single word of what I'm about to tell you. Stay with me until the very end, because what happened in that marble courthouse in Washington will affect you, your family, and every law-abiding gun owner in this country. Here's what we know. In an 8-1 decision that stunned legal experts and political analysts alike, the Supreme Court ruled decisively in favor of expanding constitutional protections under the Second Amendment. The ruling came down just days ago, and already the reverberations are being felt from Capitol Hill to state capitals across the nation. Major news outlets are calling it historic, unprecedented, and a complete game-changer in the fight over gun rights. The majority opinion, joined by 8 justices spanning the ideological spectrum, establishes a new legal framework that could dismantle restrictive firearm regulations that have stood for years, even decades in some states. Only one justice dissented, and their isolated opposition has become a lightning rod for controversy. This is not a close call. This is not a narrow ruling. This is the Supreme Court speaking with near unanimity, and the message is being heard loud and clear. To understand why this decision matters so much, we need to look at the case itself. This legal battle originated from a challenge to severely restrictive state gun laws that had effectively banned entire categories of firearms and placed extraordinary burdens on citizens trying to exercise their constitutional right. At the heart of the case was a fundamental constitutional question that has divided courts and communities for generations. Does the Second Amendment protect only a narrow set of firearms deemed to be in common use, or does it extend broader protections that prevent states from systematically dismantling gun rights through regulation after regulation? The plaintiffs argued that their state had crossed a constitutional line, creating barriers so high that the Second Amendment had become a right in name only. Defenders of the restrictions claimed public safety demanded such measures and that states retained broad authority to regulate firearms within their borders. Lower courts had been split, with some upholding the restrictions and others striking them down, creating a patchwork of conflicting legal standards across the country. The Supreme Court took the case to settle the question once and for all, and what they decided has changed the landscape entirely. The majority opinion, powerful and unequivocal, represents a full-throated defense of Second Amendment rights that goes further than many legal observers thought possible. The court made crystal clear that the right to keep and bear arms is not a second-class constitutional right subject to ever-increasing restrictions based on shifting political winds. In language that will be quoted in courtrooms for decades, the justices explained that when the founders enshrined the Second Amendment in the Bill of Rights, they meant for it to have real, enforceable meaning, not to be whittled away by regulations that treat gun ownership as a privilege granted by the government rather than a fundamental right. The opinion systematically dismantled the legal reasoning that had allowed states to impose layer upon layer of restrictions, holding that regulations must be consistent with the nation's historical tradition of firearm regulation, and that modern restrictions lacking such historical analogs cannot stand. The court emphasized that Americans have the right to own firearms not just for hunting or sport shooting, but for the core constitutional purpose of self-defense, and that this right cannot be reduced to a shadow of itself through bureaucratic obstacles and prohibitive requirements. Perhaps most significantly, the majority rejected the notion that states can effectively ban entire categories of weapons simply by declaring them dangerous or unusual, holding instead that the Second Amendment protects arms that are in common lawful use by citizens today. This is a fundamental recalibration of constitutional law, and it puts state and local governments on notice that their most aggressive gun control measures may no longer survive judicial scrutiny. Standing alone against this sweeping affirmation of gun rights was a single justice whose dissent has become the focal point of outrage among Second Amendment supporters nationwide. In what can only be described as a blistering disagreement with the majority, this lone dissenter argued that the ruling goes too far, that it prioritizes abstract constitutional theory over the real-world consequences of gun violence, and that it strips states of their ability to protect their citizens through reasonable regulations. The dissent warned of a parade of horribles that might follow, challenges to every gun law on the books, an inability for states to respond to public safety crises, and a judicial second-guessing of legislative judgments about what measures are necessary to reduce harm. Only one justice out of 9 bought this argument. Only one justice looked at the constitutional text, the historical record, and the rights of millions of law-abiding Americans, and concluded that states should have virtually unlimited power to restrict gun ownership. Gun owners across America are asking how a Supreme Court justice could read the same Constitution and come to such a radically different conclusion. The isolation of this dissent is remarkable. It reveals just how far out of step certain judicial philosophies have become with both the constitutional text and the mainstream legal understanding of the Second Amendment. The immediate aftermath of this ruling has been nothing short of explosive. Within hours of the decision being published, politicians on both sides of the aisle were issuing statements that revealed the depth of division this issue continues to create. Pro-Second Amendment lawmakers are celebrating what they're calling the most important gun rights victory since the landmark Heller decision years ago, with some already announcing plans to challenge restrictive laws in their own states using this new precedent. Gun rights organizations are mobilizing their members, preparing litigation strategies, and declaring that decades of legal defeats are about to be reversed. On the other side, anti-gun politicians are expressing shock and outrage, with some calling for emergency legislative sessions to try to salvage what remains of their regulatory frameworks. Social media has erupted with reaction ranging from jubilation to fury, with hashtags related to the decision trending nationwide, and videos analyzing the ruling racking up millions of views. Legal experts are scrambling to assess which specific laws are now vulnerable to constitutional challenge, and the consensus seems to be that hundreds of state and local regulations could be in jeopardy. This is not hyperbole. This is the reality of what happens when the nation's highest court fundamentally reorients constitutional law. Now let's talk about what this actually means for you, the law-abiding gun owner trying to navigate an increasingly complex legal landscape. This ruling could invalidate dozens of state-level restrictions that have made exercising your Second Amendment rights a bureaucratic nightmare. We're talking about laws that ban common firearms based on cosmetic features, regulations that require excessive permitting processes with months of delays and arbitrary denials, magazine capacity limits that turn ordinary citizens into criminals overnight, and restrictions on carrying firearms for self-defense that only criminals ignore anyway. Under the new legal standard established by this 8-to-1 majority, courts will have to take a hard look at whether these laws are consistent with historical tradition, and many of them simply aren't. Imagine living in a state where you've been told you can't own a standard capacity magazine, where you've had to wait months for a permit that may never come, where you've been denied the right to carry a firearm for self-defense because some bureaucrat decided you didn't show good cause. This ruling is your ticket to challenging those restrictions. It means that when you walk into a courtroom, you'll have the full weight of Supreme Court precedent behind you, precedent that says your rights are real and enforceable, not subject to the whims of politicians who view the Second Amendment as an inconvenient relic. This is about your ability to protect yourself and your family, to exercise a constitutional right without being treated like a criminal, and to live in a country where rights actually mean something. And Bruin, which established that gun regulations must be consistent with historical tradition. But this new ruling goes further, closing loopholes that anti-gun advocates had been exploiting and making clear that there are constitutional limits to how far states can go in restricting firearms. We're seeing lower courts across the country already beginning to apply this precedent, with judges striking down laws that just months ago would have been upheld without question. This is the kind of legal earthquake that reshapes the constitutional landscape for generations. It tells future litigants that the fight is worth fighting, that courts will enforce the Second Amendment with the same vigor they apply to other constitutional rights, and that the days of treating gun owners as second-class citizens are coming to an end. The broader historical arc is bending toward recognition and enforcement of the rights our founders enshrined in the Constitution, and this decision is a major milestone on that journey. Of course, not everyone is celebrating. The opposition reaction has been fierce and immediate, with anti-Second Amendment groups condemning the ruling in the strongest possible terms. Prominent politicians are already calling for emergency action to counteract what they're describing as a dangerous and reckless decision that puts public safety at risk. Some are floating proposals for constitutional amendments, court-packing schemes, or legislative workarounds designed to preserve as much of their regulatory agenda as possible. Advocacy organizations that have spent decades pushing for more gun control are mobilizing their donors and supporters, warning of dire consequences and demanding that lawmakers find ways to resist the Supreme Court's mandate. The rhetoric is heated, with some going so far as to question the legitimacy of the court itself, suggesting that a decision they disagree with must somehow be illegitimate or politically motivated. This is the reality of how polarized this issue has become. One side sees constitutional vindication and the restoration of fundamental rights, while the other sees catastrophe and a threat to public safety. The tension is not going away, and if anything, this ruling has intensified the national debate over the proper scope of the Second Amendment and the role of government in regulating firearms. Gun owners nationwide, this is your moment, but it's also a call to vigilance. We must stay alert and informed because this fight is far from over. It's simply entering a new and potentially more challenging phase. The legal victory is real, but the political and cultural battle continues. We need to stand together, support the organizations fighting for our rights in courtrooms across America, and make our voices heard at every level of government. This is not the time to become complacent. Share this video with everyone you know who cares about the Second Amendment. Leave a comment below telling me what this ruling means to you and your family. And most importantly, subscribe to this channel and hit that notification bell so you never miss an update on the legal developments that could affect your right. We're living through a historic period, and every gun owner needs to be part of the conversation. As we close, remember this. The Constitution is not just a piece of parchment locked away in a museum. It's a living guarantee of your rights, your freedoms, and your ability to protect what matters most. Today, 8 Supreme Court justices affirmed that the Second Amendment is real, enforceable, and deserving of the same respect as every other constitutional right. This ruling will reverberate through courtrooms, legislatures, and communities for years to come, and every American who values liberty should be paying attention. Stand firm. Stand informed. Stand for the Constitution. In the coming weeks and months, we'll be bringing you updates on how this decision is being applied, which laws are being challenged, and what it all means for gun owners across the nation. This is history in the making, and you're part of it. Until next time, stay vigilant, stay free, and never stop fighting for your rights. God bless you, and God bless the Constitution of the United States of America.